Hello, hello. Welcome. Welcome to Rush to Judgment with Jessica. And I'm Jessica. Hi. Welcome back. Welcome to. I would like to introduce myself. And again, I'm Jessica. And I just want to let you know that here we just like to comment and make light and um, make things a little bit better or easier to go through. I think right now we are getting through the rest of the George Zimmerman and Trayvon Martin case. Um, we are very close to finished. As of right now, we are about very, very close. I would say we just have a few more videos and then we are down to the last closing arguments. And then that's it. So, and I think this one is some just bickering between the lawyers, and I believe the defense has rested, so, or is about to, or did. I don't remember the last video. They're all just kind of running together at this point. But anyway, I just want to refresh anybody's recollection or just make sure I tell you this. I'm not an expert. I do not specialize in any particular area of educational information. I'm not a specialist in anything. I'm not a lawyer. I am not a doctor. I am not of anything. I'm just a regular old person just sitting here giving my comments, giving my opinions, giving my smart ass remarks to things. Because this is what I do. This is how I live my life. This is how I watch things, and this is my normal reaction to things. This is the first time I'm watching things. So if the videos are strange or the videos don't turn out right, I don't pre-watch them. Could be bad on my part, probably is, but I think it's a more authentic way to excuse me, to go about this. So yeah, my reactions are legit and authentic as far as real. So anyway, I'm just here to give my opinions or my critical judgments on things. And I know I'm a big fan of the cuss words. So if that's not your cup of tea, then I apologize or I don't apologize. I mean, that's fine. But yeah, so anyway, this is just a little bit about me, a little bit about what's going on, and we can go ahead and get into this. These are some arguments between lawyers about, I believe, the state tried to call a rebuttal witness, and okay, so the defense did rest, and the state was trying to call a rebuttal witness, which was the gym guy that was training George Zimmerman, and basically called him soft, and he wasn't a fighter and whatever. But he called. They were calling him to tell him or put him on the stand to basically ask him if he had a financial investment in this, and that he was marketing a training for training George Zimmerman, which honestly, personally, I feel like that's not a real good marketing plan. Yeah. But anyway, but that's the defense objected to that. And now they're putting in a proffer, and then they're going to argue about some other things. So that's where we are on that one. So, all right, let's get into it. Put that up there. And we start the plan.
You asked for additional potential citations to authority, Your Honor. I would tender one, McKee, MCKEE versus State. That is 712, 7 second, 837. Generally standing for the proposition that evidence relevant to a witness's possible bias, prejudice, motive, or intent is nearly always necessary to inform the jury of any motives regarding, in this case, it was a prosecution witness, but I think it applies equally. So again, in addition to the Britton case that I cited, the evidence would be admissible for that purpose.
But what about the rule, the evidentiary rule that you can't call a witness for the purpose of impeaching?
Well, not necessarily calling him to impeach him, because impeachment would mean that I am contradicting some of his earlier testimony. I am perhaps calling him to impeach the testimony of Mr. Root. That's not calling him to impeach this witness. If this witness denies or says something that is contradicted by the actual written record, then it may be necessary to impeach him, but I don't think he's going to deny that that's on his website. He may offer an explanation.
What is within the website
He's so goofy.
that would contradict any evidence offered by Mr. Root?
Well, I don't know that. Well, as far as contradicting, he said that I believe he characterized Mr. Pollock as uninterested or unbiased or one of those, that characterization. I forget the exact word he used, but that he placed extra testimony or extra weight on his consultation for that reason. So it would not necessarily just contradict. I think it's also either contradict or help explain.
Okay, fine.
It has to, if it's impeachment, it's impeachment, and it has to impeach something. So let's talk about what it's being presented for. And we read from the same Bible, so I looked at Earhart for some insight on this, and what he says is that it actually has to be relevant. It has to truly impeach or address an issue of bias. In effect, what we're looking at is this witness's, Mr. Pollock's bias and how he may have presented in a way that evidences his own personal financial interest, which I guess is the underlying request of the state, that they impeach or make believe not impeach, but impeach this witness by saying, you might be trying to make money on Mr. Zimmerman because he came to your gym. Let's just think this through for a second. And I think the court has to include within its context of authority, common sense. So let's look at it through common sense filter for a moment. This witness who wants to tell somebody to come to his gym because I trained Mr. Zimmerman, got in front of this witness, in front of this jury, and under oath said he went from a 0.5 a year when he first got to me to maybe a 0.1, that he was soft then and he's soft now. There's no financial interest that this witness furthered by his testimony. That's why it's sort of bizarro impeachment, because it doesn't impeach what it would normally impeach. If this witness came in and said, this guy is great, and because of my training, he can kick anybody's butt, then maybe I would come in and say, wait a minute, aren't you making money by saying that you do a great job? We don't have that. We have the opposite of that.
Okay, what we have here and what the state had cited to the court was Britton versus State, 414, 7 seconds, 638, and it is a 5th District Court of Appeal case. And in that case, the state didn't call this witness in their case in chief and called him in their rebuttal. And the court indicates that rebuttal evidence explains or contradicts material evidence offered by a defendant. And the testimony delivered by the state's rebuttal witness was neither explained nor contradicted any evidence offered by the defendant in that case. Permitting the testimony, however, was not error because the court has discretion in the order of presentation. What you're trying to do with Mr. Pollock is not an order of presentation. It is to impeach your own witness. You're calling him as a witness to impeach him by saying that he's advertising on a website about the Zimmerman trial and the Zimmerman training that he received at the gym. I don't think that that's allowed, and I'm going to sustain the objection. So I don't know how you want to handle this in front of the jury. We could tell them that Mr. Pollock is not going to be testifying, and you could call your next witness.
So that means
have
he
him
does
come on here if you
not
have any other
get to
questions
call
that you
them.
wanted to ask them.
And this
This
poor
was the
man
sole
done came
purpose?
up here.
Yes, Your Honor. I was going to call him and ask him about that particular website advertisement.
All right, well, then the state agrees based upon the court's ruling. There's no reason to have Mr. Pollock come back into the courtroom.
Yes, Your Honor.
All right.
The next witness similarly has some objections to the presentation.
Oh,
made, so
the
take that
poor
up before the
goofy
jury comes back
boy.
in, if we could.
Poor thing.
All right, and the next witness's name is, please? All right, and what is the purpose for calling Mr. Lee?
Judge, could I have just a moment?
Yes, you may.
Mr. Clark is going to be released from his.
Yes, Mr. Pollock will be released.
Well, somebody gonna go tell him?
Judge, nothing else. The state is not going to be calling Mr. Lee.
Right, and how about the other witness that the state was going to check on for tomorrow?
I haven't left the courtroom to be able to check on that, Your Honor. I haven't yet known.
Surprisingly, we have an objection to the presentation of that evidence as well, maybe to address it.
Maybe we can proffer it. What is the name of that witness
He is Mr. Fleischman, Your Honor.
and his first name?
I believe it's Arthur.
Arthur? And what is the objection to that?
You don't even know your own.
He is the agent with the Bureau of Alcohol, Beverage, and Tobacco for whom the defendant was arrested for committing battery on a law enforcement officer. That is who he is.
Okay, and the purpose for calling him?
Because the defense has gone to great lengths to assert that the defendant is, despite all the other circumstances, largely incapable of fighting. I think this agent would offer a different perspective on that, where he could be permitted to testify. Specifically, he would essentially say that while he and some of his fellow law enforcement officers were engaged in arresting some persons at a bar at which the defendant was, that they had the individuals outside subject to being arrested, and the defendant came out. One of them, or at least one of the people being arrested, was one of the defendant's friends. This agent in particular will say that he identified himself to the defendant, showed him his badge and identification, told him that he needed to leave while they were effecting the arrest of these individuals, and the defendant actually attacked him. That would be his testimony.
My response to him, one, it's a prior bad act that the state is trying to get in improperly, firstly. Secondly, of course, there's a 403 analysis that needs to be done by this court. Thirdly, you need to probably know a bit more about the facts of the case so you can address it. The agents were undercover at a location out by UCF and had taken a friend of Mr. Zimmerman's
I
out
can't get.
bodily because
Can I
he
have
made,
a time frame in this, please?
it is 2005, Your Honor, so we're talking 8 years ago. Before, just so the court's aware, before he wanted to become a prosecutor, before he got his concealed weapons permit, where they did a background check, before he did the ride-along with Sanford Police Department. The reason why all of that was probably able to be accomplished by Mr. Zimmerman was that in 2005, when these agents grabbed his friend, who seemed to be underage, dragged him outside, and I think they'll probably acknowledge that that's how they accomplished it. Mr. Zimmerman, since they weren't playing,
Oh, no.
that at some point they brought out their lanyards, but I think this court, previous court, Judge Lester, when he addressed this very same issue, I think opined succinctly that the way that these things are handled out by UCF is that the agents go in there sort of, I don't know if you use the word Gestapo, but something like that. Anyway, so they take him outside. Mr. Zimmerman goes outside to ask exactly what transpired. The officers didn't like the idea that someone was getting in the way of what they thought that they were doing properly. And they arrested Mr. Zimmerman. I never heard that they said that he attacked him. I don't think that's in the police report. Maybe Mr. Manti can proffer the police report to the court. But in any case, he was arrested for battery on a law enforcement officer. That went to the state attorney's office, who dropped it down immediately to misdemeanor, which you know from your experience, they hardly ever do on true police victim crimes. They just don't do it, and they're told not to. Not only did it drop down from the charge to a misdemeanor, but then also opposed to the normal procedure of a case like this, it went to pretrial diversion. Having gone to pretrial diversion, he successfully completed that. He dropped the charges completely. So 8 years ago, he was in fact over arrested for something. The initial prosecutor to review it identified it as being an overcharge, dropped it down to misdemeanor, pretrial diversion, and it was dismissed outright. It bears no significant probative value, both because it's ancient in time, it's ancient in act, and the way it was handled by the system suggests that it was a non-event even to begin with. I want to make sure that we're
Prior
clear,
bad
however,
act.
that if in fact the state brings in this one prior bad act, suggesting that my client is now a fighter or something, that the very
Really
witnesses
similar.
that the state attorney's office has relied on throughout
They
this
don't
case,
really have a lot of
particularly those
similar
interviewed by the
aspects to it.
Department of Law Enforcement, and most particularly the Federal Bureau of Investigation, when they did their "Are you a racist?" interview of everybody who my client talked to, including family members, a lot of people from retreat.
Okay, can you get to your point?
The point is that there are probably 30 witnesses
You
who
get
counted
to your
this one
point.
witness that my client is peaceful, nonviolent, friendly, mellow, and everything else.
Can you get to your
Information the
point?
state, and the reason why I present it now, information the state is
I
well
told you
aware
when
of.
we were at the bench, I really don't like these, you do this, I'm going to do this argument. Everybody, each side is available to present whatever case that they want to
Yada, yada,
present within the bounds of the law and the rules of evidence. And they do so at their own peril for opening any doors that may be available. So I don't, you all are experienced lawyers and you know what you can and cannot do or should and should not do. So I don't want to hear, if you do this, I'm doing that. That will be based upon a ruling from the court as to whether or not any particular door has been opened from either side. Mr. Manti, you have indicated that you don't even know if this witness is available. We now know what information you seek to elicit from this witness, and we can have argument if he is in fact available and you're seeking to have him testify. We can have argument before he testifies. Are there any other rebuttal witnesses that the state would be seeking to call? Right. Based upon that, I don't know if you're going to have any rebuttal, so we'll wait to see whether or not.
There's been no rebuttal. I don't think it's appropriate.
Well, I don't know whether or
Oh,
not.
If you allow this, I'm sorry.
So we'll take that issue up tomorrow. I would like to then inform the jury as to where we're going in this case. So there'll either be some more testimony in the morning. We'll do our jury instructions tonight, finishing them up in the morning. And I'd like to tell them that we're going to start closing arguments tomorrow. How long does each side anticipate that they will take in closing?
Since we have opening and closing in terms of, I would say 3 hours.
That's
I presume that
ridiculous.
only one attorney will be handling closing for the state, correct, as per your normal course?
I think in any other times that we allow another attorney to do the rebuttal, I've always done it that way. So if that's how they choose to do that,
I object.
okay. Your objection's overruled.
Noted.
I think 3 hours is certainly enough.
Are there going to be a lot of conversations or rulings having to be made by the court concerning the jury instructions, other than what we do with a self-defense instruction in light of the Supreme Court's review of that instruction?
There's that. There's an addition based upon a case that I've just mentioned to the state, but can present to the court as well, as Gibbs versus State, which is a slight modification to the self-defense instruction to identify a word that's not otherwise defined. I'll tell you now, I'll tell you when we get together. Then there is a circumstantial evidence one that I think that has certainly been presented to the jury as an existing element for them to consider. And
When do you anticipate having your proposed instructions to both the state and the court?
I told him I'd get to him tonight, so I'll get him the case law and those are the two instructions. We have some argument on the inapplicability of manslaughter to the facts of this case. I'd like to argue that with you at some point. I think those are the three main, with consultation with Mr. West and my client, there may be a couple of other polishings, but I think that's.
How long do you think that argument is going to take on the jury instructions? I'm just trying to get a
Sure.
feel for time.
Oh, I think half an hour. But I mean, I think it's pretty straightforward. Circumstantial evidence is what it is. I think it's discretionary with the court when the facts support it. It's allowable, so I'm not going to retrain anyone on that. The Gibbs case just defines provoked because it's not otherwise defined.
Okay, and if you're not ready to present that to the state yet, I'd rather wait for the argument. I'm just trying to get a scheduling
Sure.
idea right now. If I were to release a jury to recess for the evening and bring them back at 10 in the morning, the state can start their 2 hours. If there's not going to be any further rebuttal, could start their 2 hours portion of their closing statement. They could go to lunch. The defense can do their 3 hours and the state can do their hour rebuttal, and we can get it to the jury by tomorrow evening or have them recess for the evening and come back Friday morning. I'm going to leave it up to them as to how long they would like to do that for. So
Is now an opportunity, maybe after the jury's
we need
released,
to do the Donnelly hearing
to
also.
Donnelly, and also to address the issue of the rebuttal. And the reason why I suggest that now rather than tomorrow is if you allow that, we may well have, I don't want to use the quid pro quo argument to you, but that's going to take a lot of work to get rebuttal witnesses together, a great deal of work, including all the other witnesses to that event. And the
Well,
other,
none of this may even occur if that witness is not available. Is there any way that you can let this court know sometime soon whether that witness is available at all?
Yes, Your Honor, I'm trying to check now, actually.
It may be a non-issue.
okay, well, we can see if we need to have the argument, I guess. Okay.
Let's go ahead and bring the jury in. I'll excuse them for the day, and then we'll begin on Donnelly. Go from there.
You are also then going to address the argument whether or not that door has been opened before they begin their rebuttal and whether or not it's appropriate? I just want to make sure that's not waived. It's sort of-
Nothing has been waived. I just want to know the availability of that witness because none of it may be an issue.
You should record clear as they're coming in. We did file the judicial notices on the pleadings and exhibits.
Please be seated. Please. Ladies and gentlemen, again, we have some more work that we need to do outside your presence, and instead of keeping you back there in the jury room, I'm going to let you recess for the evening. I just wanted to tell you the state of where we are. I hate to ever tell anybody what I anticipate will happen because as soon as I say it, something else occurs. Please be seated. What's been handed to me as State's Exhibit 213 is that the create.
That's a
Exhibit.
replacement, Your Honor.
Okay, both sides agree? And then I've been handed the Defendant's Exhibit 40, which is the weathering.
Now we're just gonna argue.
47. Both sides
We're
agree?
gonna argue about things.
Then you are going to look at Defense Exhibit 39. Is there any objections to that?
Judge,
Trish?
they emailed it to me a few minutes ago. We're verifying it, so there shouldn't be, but I just want to verify it. So it might take a little bit longer because they revised it and we just need to check.
All right. Are we ready to proceed about the state's motion for sanctions regarding Mr. Donnelly?
Yes, Your Honor. Your Honor, previously the state had filed a request to have Mr. Donnelly's testimony stricken in part due to the discovery violation that was asserted based upon his radical change in his testimony. And while the court found that there had in fact been a discovery violation, he found that the state had failed to establish enough procedural prejudice under the Scipio, SCIPIO case, and as well as Evans and Cassica that we had discussed at that time. And so the request for any curative measure at that time was denied.
I don't
However, I did
understand.
indicate to the court that we believe that there was some
I don't
indication
understand
that the
how
witness, in addition to that
you can
discovery violation and
request for
changing his
somebody's
testimony,
testimony to be
had apparently
stricken.
been present in court.
It's out
Did not have
there,
the
it's done.
confirmation at that time. However,
And
I
this
have since
witness's
obtained it.
testimony
We
didn't
did
really
provide counsel
hinder
and the court
anything.
as well copies of photographs.
He just
essentially
said, yeah,
clips
that
from
was his
videos.
voice.
The witness, Mr. Donnelly, was in fact present at
Whatever.
least 2 days of the court proceedings, that being the 25th and
He
26th
said
of
what?
January, seated with or immediately
10 other
behind
people
the
said.
defendant in the defendant's family section.
Okay,
And is captured on those screens and is
Dismiss
present.
it.
I don't think there's even any real dispute.
And
with
the
that
jury's
dispute.
gonna
My
be like,
understanding is that the
well, why?
concession is that it is in fact that witness.
why is it not on there anymore?
It is subsequent to his sitting through 2 days of
What are you
testimony, which
hiding?
included a number of witnesses, including Diana Smith, the crime scene tech, and significantly Jane Serdyka, who identified the voice that she heard screaming as a younger man's voice, a boy's voice, I think was her word, something to that effect. Following his presence in court, the witness went home on the weekend, decided to listen to the tape, contact Mr. O'Mara, and we know the history from there. I will point out that even since that time, we have learned that similar things have happened with 2 additional witnesses. As we learned yesterday during the testimony of the defense witness, Mr. Shoemaker, witness John Good, who remained under subpoena and subject to recall, actually met with defense counsel as well as Mr. Shoemaker to discuss and address and adjust and therefore change the defense animation exhibit. Further, right here today, we heard from Ms. You'll have to forgive me, Bertalan, who also indicated that she was present and had watched, or maybe not present in court, but had watched and participated, had watched and observed at least a portion of the trial proceedings, including the testimony of, I believe she said, the defendant's uncle. And so we have, I think, established now, as far as procedural prejudice goes, that the witness in question, Mr. Donnelly, subsequent to sitting in court for 2 days, took it upon himself, I think is his representation, to go ahead and do something which turned him from as the case law indicated earlier, a non-witness into a witness. And Mr. Good certainly was in contact with and discussed potential testimony as well as actually a defense exhibit, again, in violation of the rule of sequestration. As it relates to sequestration, I think that the relevant case law as it relates to what to do about potential violations of that rule is set forth in the 4 cases I provided to Your Honor. Again, I think the Scipio and Evans and Cassica line of cases indicate that there does need to be some showing of procedural prejudice. I think the change in testimony, as well as the discussions had with Mr. Good in particular, as well as to a lesser extent the third witness that we heard from today, Ms. Bertalan, certainly the cumulative effect of all of those are the ones we know about at this point in time, have sufficed from the state's perspective to establish that there has been some procedural prejudice now, sufficient for that. As far as the violation of the rule of sequestration, obviously the court has contempt powers over and above and independent of any of this. However, the cases that I've cited to the court are, first off is McKinsey, McKinzie, which is the first DCA case, 845 Southern 2nd 316. And the first issue or the first order of business is to determine whether or not the violation was with knowledge or consent or connivance of the defendant or his counsel. I believe, as to Mr. Good, the representation I've heard is that certainly that was with the knowledge of counsel. I don't know. I think the representation as to witness Donnelly has been that that was without necessarily the knowledge of counsel, although whether defendant or any other member of his family knew, I think is certainly open to question given the location in the courtroom that the witness was observed. Second issue is if it is not with such knowledge, connivance, or consent, then the second way to determine this, and I'm reading from page 2 of the court's copy at the bottom of the left-hand column, second test to determine whether sequestration violation should preclude the witness from testifying, and the state's position is, since they've already testified, the remedy is, at least as to Mr. Donnelly, the prior request to strike his testimony and give a curative instruction, was put forth in Steinhorst versus State, that's Stinhorst. The Supreme Court restated an earlier holding from a case called Dumas, D-U-M-A-S, further explained that the test to determine whether to exclude a witness is whether the sequestration violation changed the witness's testimony from what it would have been had the rule not been violated. So again, before I get to the other cases, the change in the testimony, certainly there's been a change in the exhibit, the animation, as testified to by Mr. Shoemaker, and I think Mr. Donnelly's change in testimony is pretty radical and pretty evident. He went from testifying in his deposition that he hadn't heard anything and didn't recognize a voice to testifying at trial that he had heard something now and did recognize a voice. The next case is Scott versus State. That's 17 Southern 3rd, 766. It's a case from the 4th DCA. And I believe it's references page 4 of the opinion in question, or the copy. I'm sorry, beginning on page 3 and continuing on to page 4. But beginning on page 3, in this scenario, there was a defense witness who was present in court and then opted to express her desire to testify. She was attempted to be called by the defense. The court ruled, much like this court has ruled, that there had been a discovery violation. I don't know that this court has yet determined whether that was willful or substantial, but the trial court in Scott did, and expressed concern about the violation of sequestration, and then said that the court believed and found that the defendant was not acting in good faith, but purposely trying to thwart the prosecution, including dropping the witness on the lap of the prosecution at 1:30 yesterday. I think the court's comments in that case are illustrative. The court said, I'm mindful of the law, but I think that Mr. Scott has been knowingly and intelligently making certain decisions in this case to his advantage and to the prejudice of the state, and to allow this witness to testify at this time would be, and the court finds will be prejudicial to the state. The court found that a Richardson discovery violation, and there is prejudice to the state in this matter that cannot be reasonably overcome based on the totality of circumstances. The court goes on to say, at the bottom of that column, although the rules authorize a trial court to exclude a defense witness because of failure to disclose the witness, the law is well established the exclusion of a witness is a severe sanction, which should be resorted to only after the alternative available remedies have been fully considered and deemed insufficient. In this case, as Donnelly, there is literally no way to unring that bell other than a curative instruction and instruction to disregard his testimony. So while we recognize that what we're asking,
They probably don't even remember it.
Not quite the nuclear option, but a severe sanction, I believe the case law supports that it can be done. The Scott court approved that in that scenario. The next case in order is Steinhorst itself, which is the Florida Supreme Court case from 1982. It begins on, I believe, page 7 of the copy of this court's opinion. At the very bottom, headnotes 8 and 9, where they're again referencing the old Dumas case. And they indicate that Dumas does not outline the circumstances under which a court may properly exclude a witness for violating the rule. The test, however, is whether the testimony of the challenged witness was substantially affected by the testimony he heard to the extent that his testimony differed from what it would have been had he not heard the testimony in violation of the rule. Defense counsel in that case tried to show the testimony of the witness may have been affected by what he heard. The state attorney elicited testimony contradicting this. The court made a determination in the ruling. Finally, the Dumas case sets forth the older test, still valid, but as I think Scott made clear, only one of a couple different possible ways. On page 2 of the opinion, in the right-hand column, If the witness disobeys the order of withdrawal, while he may be proceeded with against for contempt and testimony open to comment to the jury by reason of the conduct, he is not thereby disqualified, and the weight of authority is that he cannot be excluded on that ground merely, although the right to exclude under particular circumstances may be supported within the sound discretion of the trial court. Your Honor, the state's position is that we believe, given both the nature of what went on, particularly as to witness Donnelly, to a little lesser degree witness Good, and to a significantly lesser degree Ms. Bertolin, as well as the cumulative nature of it and the radical change that occurred to both witness Donnelly's testimony as well as the exhibits and items discussed by Mr. Good in connection with Mr. Shoemaker's testimony. The state believes and would renew our request. Obviously, the court
I
will proceed
understand
in any
he's
fashion
gotten
it
real
wishes by
talkative
contempt proceedings
towards
against any
the
of the three
end of this.
witnesses, but we would renew our request as to witness Donnelly that the court
George
issue a
is
curative
real-
instruction to
real
the jury
chatty.
and order his testimony stricken or a combination thereof. Thank you.
If I may, Mr. Midnight. If I might approach Your Honor with some case law. Supporting different conclusions. I don't know if we're now opening the door, so to speak, to all those potential violations. We want to talk about Mr. Good and I forget who, Ms. Bertolin, but maybe we can add to the list Shipping Val, who seemed to have had a conversation with the state attorney's office where he materially changed two particular parts of his
I
conversation.
think that it's a violation of the rule of sequestration for the attorneys to have a conversation with the potential witnesses.
I didn't think so. It just seemed to be being argued by the state. So let me focus my concern with that argument.
Well, let me just, before you start your argument, as far as Bella Tran, who testified today, the state covered that in cross-examination. That's a non-issue at this
Okay.
point.
Okay.
The state hasn't asked for any sanctions regarding Mr. Good, so that's not an issue as to this point. So it's as to Mr. Donald.
My only concern is that if they're referencing these as though they want to sort of pile on and suggest that you should consider that we've ignored the rule all over the place, I have to respond to it.
The court is very concerned over the fact that there are 3 alleged instances of violation of the rule from defense witnesses, and that's something that should have been known by counsel to not have occurred. The court will tell you that I am investigating the possibility, I think the person may have been on both witness lists, of another person who may have violated the rule of sequestration, although they have not been called as a witness, but I am investigating that also, so I wanted to inform both sides. And
Great.
if you want me to tell you at a later time, I don't want to say the name
Sure.
until I conduct the investigation. But I will tell you up at the bench if you
Sure.
want to know after you finish your argument, but please go ahead.
As to the court's concern regarding Mr. Good, let's clear the record on that. Mr. Good and Mr. Shoemaker never spoke. Mr. Good was shown by me the animation to confirm with his trial testimony that it was accurate. He told me it wasn't. I had him tell me, and I knew, of course, in his testimony, the areas of concern. I then went to my expert, an expert who, as this court knows full well, could have sat in the back of the courtroom throughout the entirety of the trial in order to get that information. I think it's absurd to suggest that an animation expert can't get information from trial testimony when it is that very trial testimony that he is supposed to do. So
In all due fairness, it was my questions of Mr. Shoemaker yesterday or last night during his testimony when he said he got the information from a conference with counsel and another person. I asked, who was that other person? So that came from the
Okay.
court asking the question.
okay, just so we're clear, they never spoke because I was the intermediary to show Mr. Good the animation. He said, no, they weren't there, they were here. And I went back to my expert to make sure they came into comport with the trial testimony. So that's how the John Good issue did or did not occur, just so we're clear on that. And I guess we're not going to talk about Celine Bahador's change in testimony either, since that was just directly to Mr. Delarionda.
No, yes, I think
Okay.
that the witnesses are allowed to talk to the attorneys.
And there's, I guess, it's discovery violations or failure to notice that's will be taken up at a later time if I
Right.
file a motion.
This is relating to Mr. Donnelly, that the evidence presented to the court by way of pictures is that
Okay.
he was sitting in this courtroom after the rule of sequestration had been invoked.
Okay, let's talk then about the substance of that, and I'll then get into the case law. Mr. Donnelly was here, it seems, from my review of the evidence given to the state on days 2 and day 3 until the first morning break. And we'll have some testimony as to why he was removed from the courtroom at that point. Here's the testimony that he was exposed to that may have affected his testimony. Because I think, as we get into it, obviously, the impact on a witness and the whole purpose of the rule of sequestration is to avoid infecting one witness with another witness's testimony. So he did hear from Wendy Dorval, and you know her testimony as, so he heard that. It seems, at least he was in the courtroom for that. He heard Ms. Dorval. He also then had an opportunity to hear Donald O'Brien, the Homeless Association. And then he had a chance, after that was done, to listen to Ms. Celine Bahador, a person who never talked about the 911 tape or listened to it or heard anything, but had her own sort of interesting take on the evidence presented and her view of it. And then Sergeant
That was a
Ramondo
dig.
came in sort of just to bring in
It's a little
just
snark.
information, no substantive testimony. Similar with Diane Smith, she came in and identified a lot of exhibits, so he was able to sit through that, but there was nothing having to do with voice identification whatsoever. The second day, he heard, I guess, or at least it was in the courtroom, for Mr. Dyker's testimony. It was during that break that, and I'll proffer that Mr. West noticed that Mr. Donnelly was in the courtroom and had him leave, but we'll proffer that if necessary. So he was able to hear at least the first half of Mr. Dyker's testimony, during which he didn't say anything about anything. It was the second half. But even if he was here for that, you know her testimony to be that she heard somebody scream. She didn't listen to the 911 call. She didn't opine regarding the 911 call. So he was out of the courtroom at that point. And he's, of course, present, waiting all day to testify, to acknowledge this. But just so we're clear as to the violation. We also need to be clear as to what he changed, because I contested the state's suggestion yesterday that he changed his testimony. Because I said, well, he added to it, but the case law that we talk about, and that I'll talk to you about in a moment, really speaks to the infection of that testimony. It really speaks to how a witness has changed their opinion regarding something. What he did was not change his testimony. He added to it by, for whatever reason, waiting until 2 or 3 days before trial or during trial to make the, whatever that emotional decision was he went through, to actually listen to something which he listened to. But that was not a change in testimony, though it is added to it. And then the question is, did the violation of the rule that obviously occurred infect that testimony? I would suggest to you, since what he heard had nothing to do with what he eventually testified to, that it didn't. Did it prompt him to finally come to grips with the fact that he should listen to the tape? Yeah, maybe so. Maybe it did. But to the substance of the effect, we then have to look at some of the cases that I presented to you. Del Monte, which is a 1985 Third DC Act case, which interprets 616.1, so it gives us some insight, because you need to make a determination whether or not the rule has been violated, and you need to look into the circumstances as to what you should do with it. And Mr. Manti was straightforward when he talked about the sort of seminal case talking about this, which is the Dumas case, a 1977 Florida Supreme Court case. And basically, what that needs, that you need to look into, is to get an identification of whether or not there's been some connivance or collusion between the two, and whether or not we did this in some form or fashion to just, in effect, violate not only the geography of the rule, was he in the room, but the underlying substance of the rule. And I would suggest to you that under the Dumas case, the state has woefully failed to suggest any case law that identifies that a willful violation occurred, nor a substantive violation that may have occurred. The other case law, I might have just a moment to find it. Deals again with this court's sort of requirement to make an identification of the violation, the substance of the violation, and whether or not it's appropriate to issue any sanctions. If so, then you have the right, the most significant of which, or the most severe of which, is that you can exclude the witness from testifying. Certainly, there's nothing in the way this matter occurred as to Mr. Donnelly that suggests not only was it not the defense collusion or connivance or even knowledge, but neither Mr. Donnelly's, and you'll hear testimony from him in a moment, but to proffer it if the court would allow, when the family, I'm sorry. We weren't calling him as a witness. He was on the witness list, but as you know from what we did call him for, specific to the voice, that we were not calling him for any other reason. There was nothing that we were bringing him for substantively until Saturday came, and I found out that he had relevant testimony concerning voice, that he was even being called as a witness, just so we're clear about that. But he was definitely on. I'm not suggesting that takes him out, but I think that it does affect our presentation and what we were going to do, so that the idea that he may have been around would not have even sort of
Didn't
been
even matter.
effective to us in the way we're handling our
Keep
witnesses.
him.
And I
Don't
think what
keep
happened
him.
was
It
once
doesn't
the
even
state
matter.
invoked the rule and refused to allow Mr. and Mrs. Zimmerman to be here, and Shelley Zimmerman was here by herself, that she requested Mr. Donnelly to join the seat, I guess the row behind her. And that was just so you understand sort of how this whole thing began, with Mr. Donnelly coming into office support to Ms. Zimmerman. And again, since I had never met him, Mr. West, I think, met him at his deposition, but we had certainly not pre-tried him as a witness, as you know, we've heard some testimony here before, because, so you're clear, we had no intention of calling him. He just had nothing substantive to offer. So that just sort of comes in mind with this suggestion that we had any knowledge of connivance or collusion with the witness. So if in fact there was a technical violation of the rule, then the question is, what is the remedy? Before you consider any remedy, I think that you need to find that, in fact, not only was there a technical violation, but there was some true substantive violation. That, in effect, having violated the rule, he gained some knowledge that was able to sort of mold into his testimony before the court. And there's been no finding of that. There's been no evidence or suggestion of that. And in reality, we know what his testimony was because it was quite limited. It was limited to testimony that he created, if you will, on Saturday before he testified. And if I'm remembering correctly, and I am, that was after he had removed himself
And
from
I am.
the courtroom some 5 days before on that Tuesday, so on that
I'm
Wednesday morning
remembering
during the morning break.
correctly.
So again, if we sort of look at what happened, he was in the courtroom during a time that he wasn't going to be a witness, but still on the list, left the courtroom when advised to by co-counsel, and stayed away from both the courtroom and the trial testimony until he took on himself to listen to the tape, came to me, talked to me, and I presented him as a witness.
Me?
So I don't believe that there has been any showing under the cases I presented. Again, Del Monte, Dumas, there are some other cases, but they stand for very similar presentations. Bizard, Bizzard, just for the site purposes, that is 674 Southern 2nd, 1382. And Atkinson, federal, I'm sorry. Atkinson versus State, 317 Southern 2nd, 807. Wright versus State, a Supreme Court case back in 1985 that does give some good insight into what the court should look at before making a determination to exclude any testimony. And again, the benefit in a case like that goes towards the admission of testimony and certainly towards the defendant's right to present testimony supporting his defense. There are other cases. McKinsey was also cited by the state. Won't recite that now, but only to state that the case, the entirety of the case that I presented from the cases I've cited to McMahon at 104 Federal Reporter, 3rd, 638. Stiles versus Bergeron, Bargeron, 559 Southern 2nd, 365. Certainly give the court discretion in making
So
determination
this is
what
all going to
sanctions
be
impose,
one,
but all stand for the
this
proposition
hearing, the
that
next
before
one,
any sanction is imposed at
and
all,
then
you
part
need
of
to have
day
a
13.
quantum of guilt before you impose a
This is
sanction.
all.
There has
Just
been no
hearings.
guilt shown. There has been a technical violation without substance. And though it is unfortunate that it occurred, it was certainly not, as the state might have suggested, some course of conduct, because I think Mr. Good is now a non-issue as to how that occurred. I think that's not only not a violation, it's wholly appropriate and necessary for an expert to properly present his expert testimony. And Ms. Bertolon.
Your sequence of events here, you had indicated that Ms. Shelley Zimmerman wanted Mr. Donnelly to be in the court with her. However, she was subject to the rule of sequestration also, and that occurred either at or during opening statements. So she wouldn't have been here for the first or third day of trial, actual trial testimony.
No, she wasn't here then, but she had made the
Well, but you
request.
said that he came to support her.
My understanding was that she made the request to come by and support because mom and dad were excluded from the courtroom. Then she was excluded as well. So she asked for him to support George, in effect, Mr. Zimmerman, by sitting in the row, but he couldn't sit in the family row. He sat in the row behind her.
Well, I don't know I'm not clear as to what all the seats were, but my impression is to my left, the very first row is supposed to be a buffer row with law enforcement ability to be on there. The second row is the Martin family row, and they can choose who they want to be on that row, and they have to notify the sheriff's office and Ms. Kennedy regarding who they intend to have on that row. And then the rows behind them, except for the last row, which is media, but the rows in between are lottery. People have to go by and get a lottery to be able to be part of the public. To my right, the very first row is a buffer row, law enforcement and others. The second row is the Zimmerman family row, and they have to go through the same procedure that they have to have authorized who appears or is allowed in the courtroom on those rows. And the rows after that are media rows. Am I wrong in my seating arrangement? So are you saying that Mr. Donnelly was seated in a media row and not the Zimmerman family row?
No, I don't want to offer facts beyond my knowledge. I had not met the man. I've seen pictures, so I know that he was in that side. I think Mr. West, approached a moment ago with some better insight on the facts. I don't know. I don't want to have co-counsel argue, but maybe he can clear up those facts. I just know that I saw pictures of him in a courtroom on the right side. My understanding was that he was requested to appear to offer support to George because George's family was excluded. And beyond that, Mr. West may be able to offer some factual insight.
Okay, Mr. West, please.
Well, of course, the issue of whether or not Mr. Donnelly was here, I think, has been addressed, that he was here on Tuesday and then part of Wednesday morning, and which witnesses may have testified during the time he was here, I think is addressed. I had met Mr. Donnelly at the time of his deposition, so I was able to recognize him. And when we took that morning recess on Wednesday morning, as I was exiting the courtroom, Mr. Donnelly was standing there and said good morning, and we shook hands, I believe. That was the first time that I noticed that he was in the courtroom. Certainly Mr. O'Mara didn't, because he wouldn't have known how to recognize him. The clerk would have the time when that morning recess took place, but it was whenever that was, as I recall. I mentioned to Mr. Donnelly when I recognized him that the court had invoked the rule of sequestration and that he would have to leave the courtroom and would not, as a possible witness, would not be able to attend any of the court proceedings. He apologized to me, acknowledged that, of course, he would do that, and didn't express any knowledge specifically about knowing the rule had been invoked previously. To the extent that that was not communicated to him, that's the responsibility of counsel or staff. I don't have any question in my mind that Mr. Donnelly was not specifically informed about that. There's a couple of hundred witnesses on the list. There were efforts made to contact the witnesses that we anticipated would likely be called. And as Mr. O'Mara said, we did not at that time think Mr. Donnelly was on the list. So that's basically it. I didn't tell Mr. Donnelly, nor did anyone with my office tell Mr. Donnelly specifically prior to him appearing in the courtroom that the rule had been invoked and that he could not be here. I don't believe anyone specifically from Mr. O'Mara's office told him. To the extent that didn't happen, it's our responsibility. I have no reason to think Mr. Donnelly flaunted or in any way disobeyed an order that he was aware that the court had put in place through the rule of sequestration. So all of those facts would suggest that the violation was inadvertent on his part, and to any extent that there was some responsibility for it, it lies with myself or with staff.
Okay, thank you.
As to the Shelley Zimmerman issue,
Or when he was seated,
pardon me?
was he seated in the Zimmerman what's referred to as the Zimmerman family row, which would be the second row to my right?
I can't speak to that because he wasn't
I
seated.
can't tell by the.
He wasn't seated when I saw him. He was standing in the corridor here, exiting a row, but I didn't know specifically which one it was. The information I had was that when the rule was invoked and all of the Zimmerman family that was on either the state's list or ours was excluded from the courtroom, no exceptions, and that because Ms. Shelley Zimmerman, who of course, as the court will note, the state did not call, but was nonetheless excluded from these entire proceedings, asked Mr. Donnelly, could he be here as support for Mr. Zimmerman? So that's my best understanding of the sequence. I was not party to any of those conversations.
I fit up the question. He wasn't the second argument.
Okay, thank you.
2 points based on what I've heard, Your Honor. McKinsey, which is the 845 Southern Second 316 case, says as follows: where the violation was with the knowledge or consent of counsel, the testimony must be excluded. That is under head note 1. What I've just heard is that it was known that the witness had been here. It was known that he was then told he had to leave because of the rule. Later on, he was in fact disclosed his new testimony, changed testimony, or added testimony, however we want to characterize that. And the fact that he had previously been here in violation of the rule was disclosed neither to this court nor the state. Scipio, which is 928 Southern Second 1138, says only if the court can determine beyond a reasonable doubt that in this case, the defense, but the state, was not procedurally prejudiced by the discovery violation, can the error be considered harmless. I would point out that even accepting everything we've just heard is true, it would certainly be within the court's purview to find that that's exactly what has happened here and that his testimony, in fact, under McKinsey, must be excluded, irrespective of the Dumas analysis. As McKinsey makes clear, these are two separate analyses. One is where counsel knew about the violation and it was not disclosed. And the other is, if counsel did not, we then go to all the Dumas factors about whether the testimony was in fact infected. I would point out that Mr. Crump was also forced to be absent from the courtroom and never called. Thank you.
Okay,
Who cares?
616.1 is
Lots of
the,
people were.
rule of sequestration and the possible sanctions. And the rule basically provides that court would determine that a violation had occurred with the knowledge or convenience of a party or counsel. It may then exclude the witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony he heard, to the extent that his testimony differed from what it could have been had he not heard testimony in violation of the rule. And I think that that is very telling to the court. And on one hand, the court is very, very, very concerned, for those who want to know, that was 4 varies, about the rule of sequestration and
In
the
case you missed it.
witnesses and counsel abiding by that rule. And the question comes whether or not the witness themselves had the knowledge. And based upon what I heard from counsel, I do not believe that Mr. Donnelly had the knowledge because it was relayed to the court that he was not specifically told. In a case like this, where there is a couple of hundred people on a witness list, it is a little insurmountable to notify every single person on that list that the rule of sequestration has been invoked, especially in light of the fact that not even 1/2 of those witnesses were called during the trial. So I cannot make a finding that he had the knowledge. Now, would his testimony have changed from what he heard? I'm not making that finding either. So the motion for sanctions is denied. And if counsel will approach for just one moment.
Denied. State is not having a good day today. Denied. Denied. I'm cold. Mm.
All right, the next order of business is going through the proposed jury instructions, and knowing that there may be some suggested changes to some of the substantive ones, the court wanted to go through just the general instructions at this time to see if we can at least have an agreement as to those. First one, although it's not numbered, it's just thanking the jury for their attention during the trial and paying attention to the instructions I'm about to give. Is there any objections from the state to this instruction? From the defense? Okay. And Mr. Zimmerman, you don't have to stand up. Do you have a copy of these instructions that you can look at them with us?
Yes, Your Honor.
Okay, if you'll please do so, I appreciate it. Yes. The very first page is the style of the case. The second page is what I just read. No, could you be seated?
Okay.
Yeah, I wanted to make sure Mr. Zimmerman had a copy in front of him.
He does, and he's reviewing with us, Your Honor.
And the second page is a statement of the charge. Any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Neither one of you have to stand while we go through these. We'll reserve as to the homicide instruction because it's substantive. And any suggested changes by either side, if you could give them to the other side tonight via email, so we can discuss them tomorrow. The same would be second-degree murder instruction. The next, we'll reserve that until the morning. The next one is possession of a firearm and discharge causing death. Is there any objections to this by the state,
No, Your Honor.
by the defense?
Substantively, no, Your Honor. I believe that it's appropriate based upon the charge. We might readdress that when we go over second degree, but I think it's accurate.
The next one is when there are lesser included crimes or attempts, and what the state has listed in the proposed instruction is manslaughter and aggravated assault. Is the state requesting these lessers?
Yes, sir.
Any objections from the defense?
We object, Your Honor, and I think that would be something to take up tomorrow.
All right. Manslaughter is a substantive one we'll bring up tomorrow. Aggravated assault is a substantive one. Possession of a firearm and discharge causing death, is that a,
That is just jury instructions.
sir, defense agree with that?
We do, Your Honor.
So number 7 will not be given if I can have an instruction that takes out number 7.
Yes, Your Honor.
Next instruction is regarding notes. Any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Cautionary instruction, any objection from the state?
No, Your Honor.
From the defense?
No, thank you, Your Honor.
Verdict, any objections from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Submitting case to the jury, any objections from the state?
No, Your Honor.
From the defense?
No, Your Honor.
And then we have a state's proposed special jury instruction number 1. We'll argue that tomorrow. Are there any other proposed jury instructions that are not covered in this
No.
packet from the state?
Don't do
Not
it.
this time, Your Honor.
From the defense?
I was using a copy that I guess I now see it. I didn't have the state's
No.
proposed
It's the
special.
very
Is it
last page.
Last page that they gave it just now. Okay, thank you.
All right. Other than what we discussed with the substantive ones that may have some changes, are there any other special instructions going to be requested by the defense?
There will be some. Oh, other than the ones we've just discussed?
Like the
No.
ones that I'm reserving on, changes that may be to that, are there any additional proposed special instructions?
No, Your Honor.
I'm going to need a proposed
Use your
verdict
phone.
form. And if you can give a couple of scenarios, one that includes both lesser included offenses, one that includes one and then the other lesser included, and then they have to include the firearm. Are there any other matters that we need to take up this time regarding the instructions?
No, Your Honor. Thank you.
Just so I'm clear, the defense will be requesting some proposed special instructions, but we're going to
Just
get those later.
changes to the instructions on the substantive charges. Is that correct? And those will be exchanged tonight via email. Well, you could talk after court about that. Otherwise, they would email it to the state overnight so we could be prepared to talk about it in the morning. It's going to take more than an hour tomorrow to go over these jury instructions.
Hour or so.
So then we'll be back in
according
recess at 8:30 because I have the jury coming in 10 for closing arguments.
to I'm going to ask that we delay closing arguments for enough time to give both the state and the defense time to prepare for what we have to do tonight, tomorrow morning, and then for closings. There's a lot of testimony, a lot of evidence, and
All
it
right.
just.
We'll begin closings at 1. And we'll let the state go through their closings. The defense can do their closing on, tomorrow is what, Thursday, Friday morning. The state can do the rebuttal Friday morning. I can charge the jury and they will go out to deliberate Friday afternoon. Does that give you enough time?
Judge,
Then I need to let the sheriff know that we don't need the jury until 1 tomorrow afternoon. And counsel, what time do you want to come in and go over the jury instructions?
I thought you said 8:30, but
8:30 is fine.
I just didn't know if you asked me to change that.
Well, we just talked about it and you
Oh,
said you
sorry.
wanted time for your closing. I don't know how much time the state's going to need. Do you want to start at 10 o'clock on the instructions? Do you want to start at 10:30 on the instructions? Or do you rather do it in the morning? Because you're not going to start your closing till 1 in the afternoon.
Early in the morning would be better, and Mr. Manti will be representing us. I just need to update my
So what do you
closing
say, you
argument.
get to sleep later than?
No,
Mr.
I'll be here.
Manti?
I'll be here at 7 or earlier, probably 6:45. But I'm just saying, I would like to have more time to be able to input whatever changes are made into my closing argument presentation. So I would prefer at 8:30 or 9 o'clock if we could.
9 o'clock it is. Court will be in recess till 9 o'clock. We'll have the jury in at 1. Is there anything else that we needed to take up tonight?
Now that we've moved to Friday, does it not make sense to just start closings Friday morning? And then this way we get all the closings in one day and the jury gets
The
started?
reason I told you what schedule I wanted is because it makes sense to me. Okay, and it gives you the time, gives you plenty of time to prepare. for
Yeah,
it.
it makes sense to
The
her.
state has indicated they don't need any more time, so we'll be in recess till 9 a.m.
All right, so we are moving on to the next
Well,
one.
let's get his-
to the next
But that would be the only thing
one.
he would have to plug into his.
But this is day 13, so
That the state does. The court.
that's how that's gonna go. Oh my God, what are you doing?
We're not asking the court to instruct the jury that wearing a hoodie and walking in the rain is also lawful activity. There is a separate instruction altogether.
Police where they went, by car, on foot, what have you. That's not
He just
legal
got right
provocation,
into it.
and it would be error, and frankly, promoting miscarriage of justice if the state were allowed to argue that to this jury.
Dog.
Whether or not there's unlawful activity. We're not asking the court to instruct the jury that wearing a hoodie and walking in the rain is also lawful activity. There is a separate instruction altogether.
We're not there yet.
I understand. We're talking about whether or not the totality of the.
We're still under the 776.041,
Yes.
and the defense doesn't want it, the state does. The court is not going to give it.
Nope.
The next paragraph in the defense version starts with, however, before you can find George Zimmerman initially provoked. That's in the defense version. It's not in the state's version.
Gonna give it.
Do you want to talk about that?
Well, my understanding is, from what I heard
Do you
before,
want to
that it's
talk
only
about that?
there in the defense
Because
version
of 776.
because of 774.041. So if the court is giving none of that, I would assume they don't want that in there either.
Okay. Then we go to the next one in the defense is, you are further instructed that merely following Trayvon Martin by car or on foot in order to report his location to the police is not sufficient for you to find that George Zimmerman provoked the use of force against himself by Trayvon Martin. Before George Zimmerman can be found to have initially provoked use of force against himself, George Zimmerman must have used actual force or the threat of force against Trayvon Martin.
I think that's the same issue.
So all of that comes out too. Is that correct?
It was all part of the extended
Just making sure we get everything here.
project.
The next one is a paragraph that says, in deciding whether George Zimmerman was justified. I don't see any differences in those paragraphs. Am I correct?
Yes.
That's acceptable to both sides?
So is the next paragraph.
Well, on the next paragraph, interestingly enough, both of you did not follow tally and take out comma. And cases have been reversed because of that infamous comma after the words including deadly force. That comma should be removed based upon tally versus state at 106, 7
Jesus, cases have been removed.
Do we
The
agree?
reverse
I agree, Your Honor.
because of,
Okay, so that comma, do
Comma.
you agree, Mr. West?
that's crazy.
That would read, stand his ground and meet force with force, omit the comma.
No, that comma stays in.
Oh.
The including deadly force, that comma comes out.
Oh, sure, that's fine.
Do both sides agree with that?
Yes, Your Honor.
Do you agree that that complies with tally?
I do.
Okay, so there's no other issues in that paragraph. The next one in the defense version is, you are hereby instructed that following someone by car or on foot in order to report their whereabouts to the police is not unlawful activity under Florida law. What case law or statute or anything do you have that supports that requested instruction, Mr. West?
It is an accurate statement of the law.
Show me where that's codified.
Well, in this instance, it's sort of codified by
Where,
absence,
though?
in the sense that there is no criminal statute that makes it, that
Figure
criminalizes
out-
the act of
yeah.
following someone on foot or by car.
Well, you're free to argue that, but I don't think that that should be included in the law that the court gives to the jury.
That's our theory of defense. We're
And you
asking,
can argue it.
well, I'm asking for instruction as part of our theory of defense because, and I think this is critically important because of the facts of this case.
She's gonna yell at him.
Thinking back to jury selection,
Thank
knowing what the
you.
court knows about the way this case has been presented in the media long before that, somehow, and last night I heard people talking about this critical issue of if George Zimmerman was following Trayvon Martin, then he's guilty of something. And that's just not true. If this jury were allowed to think for a second that following Trayvon Martin is illegal, they're going to think that he committed some sort of unlawful activity under the instruction above it that the court is going to say. We know already that Mr. Manti and Mr. Del Riondo want to suggest to this jury that somehow the act of following Trayvon Martin was illegal. It wasn't. It can't, and the jury absolutely has to know that, and they absolutely have to know it from this court.
Okay.
Otherwise, just arguing it doesn't make it so. And it would be misleading to the jury. It would confuse the jury on an issue for which there needs to be no confusion whatsoever. The standard instruction says if Mr. Zimmerman was not engaged in an unlawful activity and was attacked in any place where he had the right to be, he had no duty to retreat and had the right to stand his ground, et cetera, et cetera. For the state to be allowed to suggest that by following Trayvon Martin in the car or on foot, that in and of itself suggests unlawful activity is absolutely wrong. It's absolutely, would be a misstatement of the law. It would be a factual distortion
Absolutely.
that would lead to an improper verdict. So it's a theory of defense. It's a proper statement of the law. And if you want us to tweak the language a little bit, that's different. But as our theory of
Quite
defense, we want the
honestly.
jury told by this court, it's not illegal to follow somebody, especially if you're doing it to tell the police where this person went.
Response?
The state objects. We would note that it's the first time I've ever heard unnamed media commentary cited as legal authority to the court. I would submit that while following itself might not be illegal, that following is one factor that the jury is free to consider in this case. It is something that evinces the defendant's state of mind. It doesn't have to be illegal. And I don't think the instruction, we want to talk about what confuses the jury. When the court starts telling them things like it is not illegal to walk across the street, it is not illegal to walk home from 7-Eleven in the rain wearing a hoodie, it is not illegal to be armed with a pack of Skittles. That tends to confuse the jury. It is also inappropriate for the court. Basically, this requested instruction is a demand for judicial notice of a fact in question in the case to be communicated and given the imprimatur of a jury instruction to the jury. The state contends that it is not legally proper to request it. We object to any format of this, tweak or otherwise.
Ask the state to produce the Florida statute that makes it illegal to follow somebody. And then I'm
You're
good with
asking him
that.
to prove negative, basically. And
No,
so
he-
my question to you is show me a Florida statute that says that this is a law in the state of Florida. You're asking me to put in here is not unlawful activity and under Florida law. You
No.
could
Not a
argue
lawful
that
law.
to the jury in the closing argument.
Judge, Detective Serino said so in his testimony. Any law enforcement
Well, as
officer,
far as I know, I don't think that he drafted any of the legislation.
Mr. Manti didn't say it was illegal to follow someone. He can't cite you. You know, criminal statutes are pretty precise. They're designed to put people on notice what's illegal and what isn't. So if it's illegal to follow somebody, to tell the police where they're going, there better be a law against it. Otherwise, you can't say it's
You're
illegal
all
to do that.
repeating your argument. I've heard the argument from both sides. I am not giving that instruction.
We submit that's an integral part of our theory of defense, and the court
And you
commits error
can-
by not instructing the law, this jury properly on the law.
I understand. I've already ruled, and you continually disagree with this court every time I make a ruling. I have provided you on 3 separate occasions with the court's professional conduct in the courtroom, and included in that is do not continue to argue with the court after we've ruled. If I have made a mistake in this case, you will appeal. If there is a conviction, it will get appealed to a higher court, and they can review it to determine whether or not I made a mistake. This is my ruling on this issue. You are free to communicate that to the jury in your closing argument. I am not instructing them on that. Moving on to the
would like, though,
moving on.
I'm not disagreeing. I would like, though, to move in limine at this time with regard to Mr. Della Rionda or Mr. Guy or Mr. Manti's anticipated closing argument to ask the court to order them not to suggest to the jury that following somebody on foot.
Do you want me to get into getting a predetermined transcript of what each side intends to argue at closing argument and go through it and say what can and cannot be argued?
No, ma'am,
You're
just-
free to argue
Yeah.
that.
No, ma'am, just this, that it would be an improper argument
That is
of the
what
law
he
if
would
the
like you
state
to
were
do.
allowed to suggest to this jury that it is unlawful for someone to follow another individual by car or on foot.
I'm
And
not
for the
going to
state
address
to
that
be
issue.
allowed to make that argument would mislead the jury as to the law and would allow the jury to make a decision based upon an improper legal premise. Because the state can't make that argument legally, and I'm moving in limine now for the court to preclude that specific argument. And I understand the court's ruling as to the instruction.
Okay, your motion in limine is denied. The next portion of the instruction is a paragraph
Well, damn.
going off of the defendant's suggested instruction. It starts in considering the issue. There doesn't seem to be any objection or difference in that paragraph. Am I correct?
So, Your Honor, and the next one as well.
Okay, and the next one is, if in your consideration of the issue of self-defense, it's a 3-line paragraph. There doesn't seem to be any differences. Is there any objections to that paragraph?
Not from the state.
No, I think that's the standard language now.
Okay, thank you. And then the last one, it starts with, however, if from the evidence, it's 3 lines. Is there any objections from the state, from the defense?
Agreed, that's the standard language.
Okay, so I think we have, were there any other requested changes or additions to this instruction by the state?
As it relates to the justifiable use of deadly force,
Correct.
again, having already argued and simply relying again on the case of Johnson versus State, which is also in the packet regarding the provocation instruction, no, Your Honor.
Okay, any others being requested by the defense other than the ones I've already ruled on?
Within the justifiable use instruction?
Yes, sir.
No, Your Honor.
Okay, then the next one that we have, the defense has another one, you just included in your packet the state's proposed instruction on justifiable use. Is that
I did
correct?
just for comparison.
Okay, thank you. Then there is a circumstantial evidence requested instruction from the defense. Is there any objection by the state?
There is, Your Honor. I
Okay.
provided the case of Wadman, W-A-D-M-A-N versus State, which is 750 Southern 2nd, 655. It's a 1999 opinion from the 4th PCA citing to the 1981 opinion of the Florida Supreme Court in re standard jury instructions in criminal cases, 431 Southern 2nd, 594. The instruction
So many letters.
has been eliminated by the Supreme Court. It was eliminated over 30 years ago. And the reason it was eliminated, as Wadman makes clear on page 2 of the opinion at the bottom, the Supreme Court deleted this instruction from the standard instructions, finding that where the jury is properly instructed on the standard of reasonable doubt, the circumstantial evidence instruction was confusing and incorrect. The court does go on to say that while the Supreme Court did not totally prohibit it, if the court in a particular unique case believes that it is necessary under peculiar facts to give, that a court could consider this as a special instruction, theoretically. However, they go on to catalog a litany of cases whereby the refusal to give such an instruction has been upheld. At the bottom of that page, head notes 2, 3, and 4, trial court should not give instructions which are confusing, contradictory, or misleading. And if I go beyond that for a moment, the court's opinion also issued an order on rehearing, which is found on page 3. And what the court said at the very end of the bottom of the second column regarding it is read in conjunction with the portions of the instructions that intent is an element of crime that must be proven beyond a reasonable doubt. There's no risk that the standard instructions will diminish the state's burden of proof.
I have doubt.
So the state objects to this instruction. We agree with the 30 years of precedent that have concluded it is confusing and incorrect. We don't believe that this is anywhere close to the peculiar case warranting the court even exercising a discretionary decision to give it. And I'll stop there until I hear more.
Okay, Mr. West?
Yes, Judge, thank you. I actually remember when this instruction was part of the standards. As Mr. Manti points out, that was some time ago.
Yeah.
And generally speaking, the position the courts have taken is that a specific instruction on circumstantial evidence is not necessary because of the other instructions that the jury gets in terms of how to
I'm
evaluate it.
still here.
And they're told about circumstantial and direct evidence, but circumstantial isn't defined very particularly. However, when a case is appropriate for it, it's clear that the law allows it. The Supreme Court could have easily said at any point in time, you can't give it. If you give it, it's error. They haven't done that. What they've done instead, what has happened since, if you will, is that if the court thinks it's appropriate in a given case, because of the somewhat unique circumstances of that case, it is entirely proper to give the instruction. So knowing that it is proper, in some cases, I'd like to speak for a moment about why it's proper in this case. Since if the court gives it, it's not error. If the court denies it, it's probably not reversible error, unless a reviewing court finds that, in fact, this is that case, the case where it's specific enough as applied that it should have been given. So that's sort of the standard that we're looking at. And here's why it's important in this case. First of all, in voir dire, Mr. Delarianda made a big deal, a really big deal about direct evidence and circumstantial evidence, getting the jurors to agree and understand and to basically say, okay, circumstantial evidence is just as good as direct evidence. And we know it's not, actually. It's not as good as direct evidence unless it meets the conditions or the criteria set forth here in the special instruction that this jury would have to apply in this case. It must be, those circumstances themselves have to be proved beyond a reasonable doubt. The jury needs to know that when you're comparing circumstantial evidence versus direct evidence. They need to know from this court that the circumstances must be consistent with guilt and inconsistent with innocence, meaning if they have a fact that's circumstantial, that tends to prove something the state is claiming it supports, or it could be interpreted as establishing a doubt or something that the defense claims exists, then the jury needs to know that if they have to decide how to interpret that piece of circumstantial evidence, that before they can use it against Mr. Zimmerman, they have to believe that it is only consistent with guilt and could not be consistent with innocence. In other words, Mr. Zimmerman gets the benefit of that issue, whether or not it's consistent with guilt or innocence. They must find it, in that instance, consistent with innocence and give Mr. Zimmerman the benefit of it. And, of course, that when you connect up the dots, if you will, when you pile on all of these circumstances, they must be so conclusive that it can only indicate proof beyond a reasonable doubt of the guilt. If the circumstances are susceptible of two reasonable constructions, one indicating guilt, the other innocence, you must accept that construction indicating evidence. So indeed, of the circumstances of this case, which is all circumstantial, if you will, on the issue of intent, and frankly, a lot of it is circumstantial on the core issue of self-defense, even though Mr. Root said that George Zimmerman's conduct was objectively reasonable under the information that he had. The jury has to find, was his fear, did he reasonably believe that he was facing imminent great bodily harm or death if he didn't respond with force? They're going to have to get inside George Zimmerman's head. They're going to have to take what was going on in his head under those circumstances, apply it to their own common sense, to their own somewhat objective standard of what's reasonable and what isn't, and come up with a decision based on circumstantial evidence, whether under those circumstances it was reasonable, after being hit in the nose, after having his head smashed on the concrete several times and being held down on his back, whether it was reasonable for him to have responded to that force in the manner he did. So there is no other instruction, I think, that's as specific, as poignant, as appropriate to help the jury define how to help the jury analyze the evidence in this case than this particular instruction. It could not be said to confuse the jury. In fact, it gives them the guidance that they desperately need in a case just like this one. So of course, while the court has discretion, the discretion should be exercised here to give this instruction. It's perfectly proper.
If that argument were correct, every case with a single bit of circumstantial evidence in it would get this instruction because there is some circumstantial evidence involved. Number one, that's not true. It's not the law, and it's the reason it was abandoned 30-some years ago and hasn't been given. I don't see a case relied upon by the defense here where it has been. Number two, this is, of course, not a totally circumstantial case because we have direct evidence in the form of the defendant's own statements, and there is direct evidence that the defendant shot and killed the victim. So there is no question that this is not a totally circumstantial case, which is, I would put it, the only way we even get close to thinking about giving this instruction. And if the defense's argument were correct, this instruction would be continue to be given every case where there is a single bit of circumstantial evidence. It's just not. And it's not for the reasons that are expressed in the Wadman case, because it is confusing and incorrect. So, that's what the Supreme Court said about it. The fact that the Supreme Court has said, just like with any other special instruction, there are going to be cases where a court may think it is appropriate to give this, doesn't mean what Mr. West thinks it means. The Supreme Court prefaces every jury instruction opinion they issue with the idea that the court isn't saying this isn't ironclad forever, that we'll never change our mind. Montgomery is a classic example.
I've heard your argument.
Yes, Your Honor.
I'm not going to give the circumstantial evidence instruction. The next one in our packet was the plea of not guilty, reasonable doubt, and burden of proof. And yesterday there was an indication that neither side objected to that. Is that correct?
That's correct. This is a standard instruction.
And the next one was the date of the crime, and yesterday there was no objection to that instruction. Is that correct?
That's true.
The next one was venue. There was no objection yesterday as to that instruction. Is that correct?
Yes.
Weighing the evidence, yesterday we had discussed the 1 through 5 that are always given. The state had requested the one on inconsistent statement. Court indicated it would be given. It appears in the new one, the state is also requesting the instruction that whether the witness has been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify. Is there any objection by the defense?
It's my understanding that the state wants this because there has been some testimony that experts have charged money for their services, as opposed to suggesting that someone has been paid off or bribed in some way. Is that the focus of it?
It is that, whether the compensation was financial already or expected. I think Mr. Root said he hadn't finished the bill yet or something of that variety. But yes, that is the reason. Nobody's going to be suggesting anybody was bribed. But there was
Well,
compensation.
that's kind of an interesting issue because there were some witnesses who were asked or indicated that they, I hate to use this word, but some people sounded like they were giving infomercials. And I don't want this to be construed that the jury can consider that. I think it would be misleading in that context.
I understand.
Because what the intent of any of them to give that additional information doesn't have anything to do with the defense calling that person or the state calling that person.
I understand. Dr. DeMille, for example, is one expert that comes to mind. He actually had listed the exact amount that he was paid for his work and to be.
Well, there's a special instruction given for expert witnesses that I think that is appropriate to cover this. I could see the danger of this one because of that
Just for clarification.
possible infomercial information out there. So I'm not going to give it.
Thank you, Judge. Just for clarification, unless to be argued later, Dr. DeMaio has not been paid anything. He said what he was charging.
Well, experts are entitled to be paid.
Absolutely.
So we're not going to give that number 6. So we do that the number 6 will be the inconsistent statement.
Yes,
Was
sir.
there anything else about the weighing the evidence that either side had any objections with?
No, you're nothing to say.
From the defense?
Okay.
The next one was the expert witness instruction, and yesterday there was an indication there was no objection from either side. Does that remain?
Yes, sir.
Yes.
Defendant testifying, we said was not going to be given. The defendant not testifying, is there any objections to that instruction?
No objection.
State,
Nothing to say.
defendant statements, yesterday there was an indication there was no objection to that instruction being given. Is that the same today?
This one stays.
Mr. West,
Yeah,
you don't have to keep jumping up and down. You can remain seated.
Thank you.
You're welcome.
I just thought something here, whether we're going to personalize these instructions too.
All of them.
Okay.
Everything will be conformity.
Yes. No objection.
Rules for deliberation, yesterday there was an indication there was no objections to this instruction. Does that remain the same today?
Yes, Your Honor.
Your Honor, if I may, as to the substitution of the names, do you want that in the title too? For example, the defendant's statements, the title
Everywhere.
of that? You want that to say George Zimmerman's statements?
Yes.
Yes, Your Honor.
Thank you. Then the instruction on notes, the indication yesterday there was no objections. Does that remain the same?
Yes, Your
Yes,
Honor.
Your Honor.
Cautionary instruction, no objections yesterday. Does that remain the same?
Yes, Your Honor.
Verdict, there was no objections yesterday. Does that remain the same?
Yes, Your Honor.
Yes, that's fine.
In submitting the case to the jury, there was no objections yesterday. Does that remain the same?
Yes, Your Honor.
Agreed?
We have to talk about the felony murder, third degree. One of the elements for felony murder or the child abuse portion of the felony murder is the intentionally, having an initial issue with them.
What is your issue?
Child abuse requires the defendant to have committed an intentional act.
Yes.
That's not alleged in your information.
Shooting is an intentional act.
Shooting him was an
Same
intentional.
as required for second-degree murder. Second-degree murder requires the additional depraved mind element, but I don't think it's argued that this was an unintentional shooting. The question is whether it was justifiable, but not whether it was intentional.
That's the issue that I'm going to be looking at. I'm going to give Mr. West some time to do that. The other, was there any objections to the manslaughter instruction as it is written?
No.
So the only one that I have to deal with and make a determination on is the felony third degree murder. Can we then now look to the proposed verdict form?
Judge,
With regard to the third degree murder issue, Judge, of course, the court pointed out it's one of those historically category 2, which means that it's discretionary so long as the evidence.
The state gets it if they want it, if the facts fit to it. It's not really a discretionary issue.
I disagree, but
Okay, well, I'll cite you to, I think it's Johnson versus State.
in any event, I'll look at that.
I want to make sure I give you the right citation.
But it's clear that the state must convince the court that the unique facts of this case.
Always the facts have to fit into it, and that's not the issue. The
would-
issue is whether or not, if the facts fit into it, do they get a second category 2 instruction?
there is the state's proposed special jury instruction regarding the definition of great bodily harm as well before we refer
Oh.
forms.
I'm sorry.
My understanding is the defense objects to that in its entirety, and obviously I don't intend to place it if it is given at the end, but we can discuss placement if we wish, if the court is going
Okay.
to
Let's
permit
get
it.
on the record to make sure it states proposed special jury instruction number 1, defining great bodily harm, setting the authority of Chesnoff versus State, 840 Southern 2nd, 423, 50 CA 2003. The suggested instruction reads, great bodily harm in the context of aggravated battery means great harm is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises as are likely to be inflicted in a simple assault and battery. That would be if the court was giving the instruction on the justifiable use of deadly force that included the force of the felony being inflicted on the defendant. Is that correct?
Well, I don't agree necessarily just to that. I would agree that if the court is not going to give the issue about aggravated battery, that we might remove the phrase of aggravated battery. However, even the requested instruction by the defense discusses the concept of in fear of imminent death or great bodily harm. So I think the definition and the concept behind Chesnoff and Coronado and Gordon and Owens, all those cases cited here, is defining great bodily harm so that the jury has a frame of reference. So whether the court gives the state's requested additional instruction or only the defense.
Let me see if I'm getting what you say right. You would take out in the context of aggravated battery
Yes.
and then put it in the defendant's version of justifiable use of deadly force after the paragraph, a person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself.
That would be a reasonable location. Yes, Your
Okay, any objections?
Honor. Yes.
What is your objection?
Well, there are multiple. First of all, the context of the cases cited is not appropriate for the context of the definition the state seeks in this case. There is no definition in the justifiable use of deadly force instruction for a reason, because the Supreme Court decided it didn't need to be defined beyond that within the common understanding of those terms by the jury. The state is seeking to shift the focus away from what everybody knows is great bodily harm and why that's in the instruction. And the reason it's in the instruction is this: it's not that Mr. Zimmerman sustained great bodily harm or great bodily injury himself. That is a completely irrelevant issue in this case.
Where in your proposed instruction does it have a definition of great bodily harm?
It doesn't. I gave the language that the Supreme Court used. That's the standard instruction. The Supreme Court does not define great bodily harm in the standard instruction for justifiable use of deadly force.
But the state is saying that this authority, Chestnut versus State, as previously cited, Coronado versus State, 654, 7th, 2nd, 1267, Florida 2nd, DCA 1995, Gordon versus State, 36, Florida Law Weekly, D 2590, Florida 3rd, DCA 2011, which cites to Owens versus State, 289, 7th, 2nd, 472, 2nd, DCA 1974, and C period A period C period versus State, 771, 7th, 2nd, 1261, 2nd, DCA 2000, and Len, NGUYEN versus State, 858, 7th, 2nd, 1259, 1st, DCA 2003.
Has the court read those cases?
I just see the synopsis. I do not have those
Right. And the
cases.
synopsis is the one provided by the state?
Correct.
Yes, and it's not correct.
Oh, shit.
No, these aren't self-defense cases. These cases don't deal with the definition of great bodily harm in the context of the self-defense instruction. For example, in Chesnoff, the 14-year-old victim was attacked by another, and he was punched, I guess, and kicked, and that he had swollen lips and a swollen head, so swollen that his mother didn't recognize him the next morning. The jury got the instruction of basically severe harm or great bodily harm, and the jury found Mr. Chesnoff guilty of that offense based upon the very thing that Mr. Manti suggests should be trivialized in this case. That is misleading and not appropriate in this case. Likewise, to suggest to this jury by any definition of great bodily harm like this one, which frankly is legally wrong and we object, would shift the focus of this jury not from what Mr. Zimmerman thought was happening, which is the standard the jury should apply, but to what actually happened to him. And it's a mischaracterization of the law, it's misleading, and this is just plain wrong for the jury to have, factually and legally. As the court is well aware, there are no injuries required whatsoever for self-defense. Mr. Martin didn't have to lay a hand on him if, indeed, Mr. Zimmerman reasonably believed that the use of deadly force was necessary to prevent the imminent commission of great bodily harm. Everybody knows what great bodily harm means when you're punched in the face and your head is smashed on concrete. The state's expert said there are at least 3 impacts on concrete by Mr. Zimmerman's head. That is Dr. Valerie Rao. There's no issue there. She said as much. She saw the bruising, the collection of blood under the skin. She saw the lacerations. Dr. DeMaio opined further, having seen additional injuries, further increasing the number of the minimum times that Mr. Zimmerman's head would have impacted concrete. What the state has been trying to do from the beginning is somehow shift this, not to what somebody going through what Mr. Zimmerman was going through at the moment must have felt that when you have your head banged against concrete and you're screaming for help and the person beating you doesn't stop and no one's coming to help, that's a reasonable basis to believe that you're facing great bodily harm. Just because he didn't die, just because his skull wasn't fractured, just because he healed up relatively quickly, doesn't mean that he didn't have that fear and that reasonable belief at the moment. The state is asking the court to deviate from the guideline, from the jury instructions with something specific that doesn't apply, that's not an accurate statement of the law or a definition that has been approved in self-defense cases. This is treading on very thin ice for this court, very thin ice for the court under these circumstances to instruct this jury on something that just isn't the law.
Response?
Actually, the standard jury instructions for any offense, self-defense, aggravated anything, there is no definition anywhere. That's the reason the courts have given it. Self-defense isn't sort of some special circumstance. The fact is, the phrase great bodily harm is used in an instruction. Whether it's in the self-defense instruction or whether it's in connection with another instruction isn't the point. The point is the court said, Chesnoff and Coronado and all these courts said, the standard jury instructions provide no definition of great bodily harm. And that's anywhere. That is the reason they approved the court giving the jury some guidance as to what that might be. I will first point out that Mr. West is not correct that any doctor said injury X must have come from getting your head, I think as he put it, hit on the concrete or mashed on the concrete. What they said was, it is possible, it is consistent with that happen. It is equally consistent with getting struck by any hard object, including a fist. No.
That's the, please don't interrupt each other, but I'm going to interrupt.
Yes.
You have to take each of these proposed jury instructions and the special instructions that are being requested by either side and weave it into what the evidence shows so the jury can be instructed. Your argument that you just provided to me has 2 different sides of the story. That's the jury can decide which one they believe, whether the injuries were consistent or they were not consistent. The instruction that you're seeking to have entered says that great bodily harm is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises as are likely to be inflicted in a simple assault and battery. The testimony before the court, whether the jury chooses to believe it or not, that's their purview, is that you don't have to have any injury to be in fear to the extent of the justifiable use of deadly force.
I agree with everything the court said, and that's why the argument wasn't quite finished. What we're talking about here is the defendant's reasonableness of his fear. If his fear is only that he's going to get a fist beating, for example, that is something that the jury should know in relationship to the definition of great bodily harm. In other words,
I
when
find this definition akin to what I've just stricken from the defense request, that they want me to instruct them that the Florida law is it's not illegal to follow somebody. I find this akin to that. So I understand your argument. You have it all on the record. I've cited the cases that you cited to me in support of them. They're on the record. Unless you have further argument about that, I'm ready to roll.
well, especially, the only further argument I'll make on it is this, especially since I believe that we should include the aggravated battery sections as relates before, especially since I think those should also be included. Most certainly, this definition should be included,
Okay,
Judge.
well, I've already struck those, so that's not an issue. Okay, the court is not going to give that special instruction. So there are any
Well,
other special
denied.
instructions being requested by the state? Additions, omissions, anything?
The only other one was the provocation instruction under Johnson, where because there's evidence in the record that Johnson may have initially provoked, that should be given. But those were the two, I think, that the state was requesting here, and then the aggravated battery definition.
Okay,
That's it.
how about by the defense? But we go on to the verdict form. Of course, the verdict form may need to be readdressed because of pending the court's ruling on the third-degree felony murder.
I don't have a copy in front of me, Judge, sorry.
Do you have an extra copy?
Are these the same that were submitted earlier?
Yes. The electronic version submitted this morning.
Well, I mean, for today.
Well, no, one of them is third degree.
All right, if I could have a set then. of the
Yes, sir.
current ones. Thanks.
Turning goofy over here is just annoying. Well, who's gonna talk? Who's gonna go first?
Have you had an opportunity to review it?
It's a single verdict form that contains all of the possibilities.
Okay, so depending upon what the court's ruling is on the third-degree felony murder, you think that this verdict form is correct?
I don't like the form of it, and I have some requests in that regard, but I think legally, it has the considerations that the jury must address if they find an offense to have been committed and that a firearm was used.
Okay,
Yes.
then what is your objection to the form? Because it's really not formatted correctly pending the court's ruling on third-degree felony murder, and because there's breaks in it.
I understand, but if the court were to say that you're not giving third degree felony murder, we would simply remove the middle page altogether, I think, and then it would.
Right, so then what would be your objection to the form?
The verdict form is confusing. It's confusing because of the way that it's formatted. For example, it starts with, "We, the jury, find the defendant guilty of murder in the second degree as charged," and then goes all the way through the individual enhancements, if you will.
I have to agree with the defense on this, because every time I give this jury verdict form, we have the enhancements as a separate special finding. It could be, after the defendant is found not guilty, you could say, if you find the defendant guilty of the offense of murder in the second degree, you must further find, and do it that way, because I think there is a lot to get to before you get through the possible findings by the jury as to guilt or not guilt or guilt of a lesser included.
We can do that. The only.
Okay, is that what your objection is?
Yes,
There
the
should be a
first line
special
should say,
finding.
"We find the defendant guilty of murder," and then
I
the second
understand.
line should say, "We find the defendant not guilty."
No, the way it should say, we find the defendant guilty of murder in the second degree as charged in the information. We, the jury, if I so find, we, the jury, find the defendant guilty of third degree felony murder or lesser included offense. The next line would be, we, the jury, find the defendant guilty of manslaughter or lesser included offense. And then it should be, we, the jury, find the defendant not guilty. That is how it has always been done by this court. Then there should be a section after that that says special findings. And the special findings should be the relating to the firearm. So that's,
I want not guilty on the first page.
I know you want that and every
Yeah.
defense attorney does, but it's not done.
Well, I like it in this case because all of the choices the jury has before they even see the place that says not guilty.
It'll all be on the same page.
Pardon me?
I understand your argument, but I'm not doing that.
And I think the order of the possible verdicts is also incorrect.
Okay,
So I'd like the court to address this, and that is that manslaughter is a category 1, third degree murder is a category 2. So the logical choice would be, if the court's going to give those lessers, that the first one be murder, the second one be manslaughter, the third one be third degree murder.
okay. Is there any objection to that by the state?
No, we
Okay.
have, that's fine. The only issue with that is we will then have to repeat, because the firearm findings for each of the murder counts are different than the firearm findings for manslaughter because of the 1020 life language. now you're going to,
1029 doesn't apply to third-degree murder.
that's what,
It does too.
Yes, it
applies-
does.
It even applies to aggravated assault.
yes.
Well, I'll have,
It does apply. You'll just have to put it in a way that would make sense, but the court's
We can do
ruling
that.
is going to be the charges be first and then a special finding by the jury. Before we recess for lunch, let me give you a scheduled thing. Yesterday, Mr. West, you had indicated, or I don't know if it was Mr. O'Mara, I'm getting into a housekeeping issue. You had sought to introduce into evidence defense exhibit double D, and that was the portion of a tape played in front of Ms. Gentile. And the court had indicated that my notes reflected that that tape was played to Ms. Gentile outside the presence of the jury. And I asked the court reporter to check her notes. And the email that I got back was, in cross-examination immediately after lunch, Mr. West asked questions regarding the, quote, "you want that too," end quote, part of the tape. And that was played to Ms. Gentile outside the presence of the jury. When the jury was brought back into the courtroom, Mr. West used the transcript to question her on that issue. So the court will not be admitting double D into evidence that was not played in front of the jury. As far as scheduling purposes goes, I know the jury is supposed to be back at 1. I know that Mr. De La Rianda wants to get the jury instructions settled before he does his closing argument. I'm going to say that we'll be in recess until 1 o'clock. I will take up the second-degree murder argument, and thereafter, Mr. De La Rianda will be given some moments to get his, but that would be the only thing he would have to plug into his closing argument, and we'll start the closing arguments for the state this afternoon.
For the third degree murder argument, Your Honor?
The third degree, I'm sorry. Manslaughter will be given.
who's taking responsibility for finalizing the set of instructions?
Well, the state's going to do it,
All right, I'll
and we'll
be-
review them.
Okay.
Okay, so we'll be back at 1 o'clock and be prepared to argue the third-degree murder instruction. I think all the other instructions have been resolved.
I will do my best. It's only an hour, and as I mentioned, this was all put on us this morning. I knew
I
nothing about it.
understand. I understand.
And will we have a chance to review the verdict form prior to?
Yes.
And is the state going to prepare the draft of it?
Yes, they are.
Thank you, Judge.
Would
Okay.
everyone like that electronically over the break as soon as it's completed?
I'll just take a hard copy.
Yes, Your Honor?
Thank you. Court will be in recess.
Court will be in recess. Then we will move along to the next one, which is still more hearing. Oh my goodness. But it's only 11 minutes. And then we'll
You're at the
move
podium. You want to say something?
I simply want to point out, I did, over
To
the
the
break,
closing
like to
argument.
provide 2 additional cases, one of which is, I think, more instructive than the other. The more instructive one is Harrington, Herrington versus States, 1989 Florida Supreme Court decision. Essentially, quoting one of the rules of criminal procedure and indicating that, according to the Florida Supreme Court, requested instruction on third-degree murder is if there's evidence that the killing was done during the commission of one of the underlying felonies for third-degree murder. Anytime the charging document alleges an offense which can be divided in degrees, such as homicide. In the case of degree crimes, requested instructions on all lesser degrees that are supported by the evidence must be given regardless of the allegations of the charging document. It goes on to specifically discuss manslaughter and third-degree murder in that context. So in addition to the cases I cited this morning, I will be submitting that one as well. The other one is Carwile, Carwile, and that is as it relates to allegations for intent. That is an aggravated child abuse case. So it is simply a case about when it is, and it's a JOA case, as I said. I'm not sure it's directly opposite, but I think it does point out that the court's question before we left was as to the intent, and the intent is the same for the same act. That is the shooting. That is an intentional act. It's not a separate intent that's required. So I just want to make sure I was clear. I think the other cases also make that point, but Carwile, I thought, might be instructive along those lines. And if it isn't, it isn't. But Harrington was the principal one. I just want to make sure the court was aware that I brought those up.
Okay,
I'm
thank you.
just trying to make sure you're aware of that.
Well, likewise, I just got these cases as we came in here a couple of minutes ago. I certainly haven't had a chance to read them.
I don't need you to do that. I went back and I looked at all this, and I don't think that the evidence supports a charge to the jury for third-degree felony murder on a child abuse charge, so I'm not going to give that instruction. So I have received your final draft, so it's not so final yet. The change that would need to be made is on the lessers to take out the third-degree felony murder. And then we can just excise out the charges, and and you'll finalize the verdict form. I understand your argument, but
I was only going to ask which part of shooting a child hadn't been established.
I just don't think that the intentional part of that is there for the child abuse charge, and it's not alleged in the information that way. And I just don't think that the evidence supports that. And if I'm not sure about that, I'm not going to charge the jury on it. And I think that to exercise caution, I'm going to deny that being set before the jury.
Understanding that since you're subjected to any error that's been established as reversible will be deemed waived, I hope that we at least protect the record in that regard.
Okay, thank you. So with that being done, are there any objections to the proposed final draft of the jury instructions? That would be changing the lesser included crimes to just allege manslaughter, taking out the charge on felony murder, the justifiable homicide after that, the possession of firearm and discharge causing death after that instruction. Then there was a blank page. Then the next charge would be the manslaughter, justifiable use of deadly force, plea of not guilty, date of crime, venue, weighing the evidence, expert witnesses, George Zimmerman not testifying, George Zimmerman statements, rules for deliberation, notes, cautionary instruction, verdict, submitting the case to the jury. Any objections other than what the state has already argued? Any other objections from the state?
Other than what we said, no, Your Honor.
Somebody wants to? Yeah.
The only question, Your Honor, is as to the justifiable use of deadly force instruction.
That's
once-
after the second degree murder.
After the second degree murder. Or, I think it's actually after the manslaughter.
It's after the manslaughter.
The first paragraph, I believe, is what the defense requested, other than obviously we'll remove the reference to the lesser included offense of third degree murder. But my understanding, I want to make sure I got Mr. West's requested language exactly as he wanted it. I think I did, but I'm not certain.
Are we looking at the first paragraph in the instruction for justifiable use of deadly force?
Correct.
He inserted the language with which George Zimmerman is charged. The way that I drafted it was it's a defense of the crime of second degree murder and the lesser included offense of manslaughter if the death of Trayvon Martin resulted from the justifiable use of deadly
Okay,
force.
I understand. So what if you put it as a defense of the crime of second degree murder and the lesser included offense of manslaughter with which George Zimmerman, well, let's put second degree, leave it as it is, and then after manslaughter, which is a lesser included offense,
If we could just strike.
because he's not charged with manslaughter.
Right. So if we simply struck the language with which George Zimmerman is charged, we've solved the problem. There doesn't seem to be any question that Mr. Zimmerman's charged with second degree murder in this case.
That's fine? Okay.
That appears otherwise to be,
Taking out the third degree felony murder. The rest of it
Right.
seems to be correct.
yes, I think so.
Are there any other instructions being requested by the defense?
Pardon me?
Are there any other instructions being requested by the defense?
There's a couple of occasions where words are plural that should be singular now that we've addressed the third degree murder. So I'm sure the state can
The
catch
substance,
that.
we can change that. I'm looking for really substantive
Right.
changes, but thank you for pointing that out.
So we're now addressing any other changes?
Moving along, Mr. West. That's not a pretty face, Judge. It has a very prominent
Nothing else, Stephanie?
Okay, thank you. The other
resting
thing we'll need to
straight.
see is the revised verdict form when you have that available. I'm sure Mr. De La Ronda will need to review that.
Yes, I think it's just a revise in light of the decision.
Okay, so if we were to be back here, let's say 1:30, 1:40, he should be ready to go. Can you have the proposed verdict forms to the defense prior to that? So then I could come in about 1:35 and make sure they're all in order before we start with closings.
Thanks, Secretary.
All right, with that, anything further from the defense at this time? Let me ask you while you're standing, Mr. Zimmerman, you've had an opportunity to review the jury instructions with counsel?
Yes, Your Honor.
And are these instructions agreeable with you, sir?
Yes, Your Honor.
Okay, thank you very much. We'll be in recess.
Oh, snap. Well, we're on and popping. On and popping, on and popping. The next one we're gonna do is closing. closings. 3 hours. These people get 3 hours. That's ridiculous. We have to listen to these people talk for 3 hours. Oh, Jesus. Jesus. All right. But we are gonna get it going. Get it going, get it going, get it going. All right, so there you have it, y'all. This was the hearing to go over jury instructions and verdict forms and this and that and the other. Just the boring stuff. And then they're gonna give the jury instructions and then they're gonna give the closing arguments. I don't think I have the jury instructions portion of the videos. So, yeah, but that's okay. It's fine. We just pretty much heard them. And we don't need to know them. And then we will get into the closing arguments, and then we're going to get the verdict. And that's it. Then we're done. And we're off to the next one. So, all right. Come back. Join me on the next one. Join me on the next one. All right, peace.